Depositions. Depositions is a common form of discovery where I am attempting to discover information from another person, entity, or party that will help either shed light on my case or provide me with information that'll hurt my case or help to prove something that is related to the case or to the person testifying in the case. The actual process can be done either through written questions, a deposition upon written questions. You might do something like that if you had somebody, you were in the United States and somebody was in China, and it just was not cost effective for you to go all the way across there. Or somebody was stuck in their home and you couldn't get to that home for some reason, or it wasn't economical and you wanted to send your written questions, you could send them. But the more common form is by the live taking of testimony. That is where in a deposition you actually sit down with a court reporter who is typing word for word what is being spoken. And then the other parties are present. And then the witness is sitting next to that court reporter, and they are either being transcribed or it is being videotaped or both. And you are asking questions if you're the deposer, if you're the person who's requested the deposition, and the person who is answering questions is the deponent. So you get an understanding of the way that process works. You can take depositions by phone, by Skype or some other internet-based format. You can take it in any way that is fair and reasonable to depict or be able to translate your questions in a way that they will understand the answers and be able to respond. The way you secure power over the person to be deposed is by one of two methods. Either one, by something called a notice of deposition or a notice for deposition. That is generally for parties and their agents. I don't need a separate court document, subpoena, or separate power because they're already part of the lawsuit. If they're a non-party, then it would be by way of subpoena. That is an official way of getting power over a person by a piece of paper, a document called a subpoena, which is then served almost like a lawsuit upon that person, that entity, that person or entity that is not a party to the action. Sometimes a party will say, hey, that's an employee of mine. You don't have to subpoena them. You can just do a notice because I'll produce them. If you have good professional dealings, when somebody can produce somebody, it's just a lot easier and doesn't waste service fees and court time in filing a subpoena. The notice of deposition can take two forms. You can either ask for the person to appear or ask for the person to appear with documents. If they're going to just appear, it would be a notice of deposition. If you want them to appear and you want to attach a list of documents you want them to come with, it's a notice of deposition, ducis tecum. If I had the same scenario with a non-party, if I just wanted a non-party to show up, a witness say, I would do a subpoena. If I was asking the witness to show up with documents, it would be a subpoena ducis tecum, a subpoena to bring documents. And then I attach something that looks like a request for production. It's a list of the documents that I want them to bring. And of course, the party can initiate or respond with the same kinds of objections they would in any typical request, like a request for production. If they have privileges or they don't have the documents or they're burdensome, those types of objections can be raised. Now, once you set that document up, you need to make sure the document has the correct date, the correct location, the court reporter who's going to be appearing, so that all parties know exactly where you need to be, when you need to be, and if possible, how long it will be. Sometimes it's very long and you could say it will continue from day to day. Sometimes you'll say it is estimated to take 2 hours, but it may take more. So you can set that up, and then once you try to get an agreement with the other side, You always try to work together first so that you can get an agreement on time, and most parties will figure out a way to get together. If you can't, and you have to unilaterally set it, then they can only stop the deposition. The only way they can stop it is by filing something called a motion for protection or a motion for protective order. And they must get it heard before the date of that deposition and get an order that says they don't have to appear. So you fully understand the way that works. Now, when you go to the deposition, you're entitled to ask questions which are relevant or which will lead to relevant admissible evidence. So you actually are going to sit down and actually ask questions of that witness, and that witness is actually going to respond. You may show them documents. The key to depositions is to understand that people are typing things, whether or not they're videotaped. You need to make them what I call directional, and that is if I were reading it, would I understand what I'm reading? Let me give you an example. Here's an incorrect discourse between a party and a deponent. So, sir, you were standing here. Yes, I was. You weren't there, but you were over here. That's correct. Here? Yes. Exactly right here or just next to here? Well, sort of next to here. How far? That far from about that far from the location. Are you sure? Yeah, I'm sure. Now, when you read that, how do you know what is going on? How does a judge, how does anybody review that? How do you read that in a court of law if you want to use it at trial? Because you're allowed to use sworn testimony like depositions for any purpose, including reading them at trial like testimony. What you do is you create a directional type of questioning. Sir, I'm going to show you a picture of the bank. Do you see that? That is marked as Plaintiff's Exhibit number 1. Do you recognize that as the picture of the bank? I do. Now, you'll see there are certain numbers that are listed inside the bank that represent locations. Do you see those numbers? I do. Now, I want to ask you some questions about where you were standing at the time of the incident. Now, if I point on Plaintiff's Exhibit 1 to number 3, is that where you were standing? Or alternatively, can you please point and state the number of the place on the map that you were standing when the incident occurred? Yes, I was standing right next to number 3. Okay. How far were you away from Bill? Or how far were you away from the victim? I was this far. And maybe they show hands. So let me make sure I understand or that the record is clear. Are you saying you were standing about 5 feet from the victim? Yes. Or I see you made a gesture of width. Would you tell us how far in feet you were standing next to the witness? I was standing 5 feet. Do you see what I'm doing? I'm making it directional. This allows me to make a record that is easily usable, whether I have complaints or problems or whether I'm trying to show a jury something. It would reflect a more accurate picture of exactly what's going on. That's the quintessential way to succeed in depositions. Now, there are different styles of questioning. There are questioning that's open-ended, closed-ended. You can lead a witness. It depends on who you're deposing and what you're trying to accomplish. The important thing about a deposition is to have a point, to understand what is the most knowledge I know about that person and their potential role in this litigation. Were they there as a spectator? Are they going to testify that they saw something? Did they write something? Did they deliver something? Did they view something? Are they the actual person who was injured? Because that will set up a framework for you of if I know who it might be, then I can start to develop questions on what I might ask. I recommend that you draft questions because it is the best way to keep order and also so that you don't forget. It also allows you to ask additional questions without losing your place. For example, if I ask somebody where they went to school because I want to know their background, and they say, I went to Boston College for my first 2 years, and then I went to the University of Alabama, Crimson Tide, for 2 years to complete my degree. My next question might be, tell me what you did after college. But I realized that they went to 2 different schools. So I can say, Can you please explain why you went to Alabama after 2 years? You know, what was the reason for changing schools? Well, I was thrown out of school. Or, well, I wanted to go to another school because it was close to home. Now I can go back to my questions and pick up that I know that whenever I exhaust those questions, I'm back to my list. So you can see how being organized and directional and having a point to your message is going to be great. It's always beneficial to ask open-ended questions at some point in the deposition because you want to get as much information as you can without telling the witness where you're going. So you ask questions like who, what, where, why, when, how. Please tell me. Please explain. Please articulate. Please list. This way, the witness doesn't really know exactly what you're asking or how much to give, and they're more likely to give an honest answer. Where were you at the time of the incident? Now, you might think that the person would say, I'm standing right here. But what if they were to say, I don't really know what that guy's asking, so I'm going to say, well, I was standing 3 feet to the right of Bill and 2 feet next to Jim, and I was standing with my head turned to the right. Wow, I just got some more information that I wouldn't have gotten. So I want to ask open-ended questions. What did you do after you walked into the store? He doesn't know or she doesn't know what to answer. You're not suggesting an answer, you're asking them. And whatever they answer will be probably good information. If the person says, well, when I walked in the store, I looked to my right and says nothing else, then you pick up by asking questions from their answer. After you walked in the store and you looked right, what was the next thing you did? And if the person plays games and said, well, then I look left. After you walked in the store and looked right and looked left, then what did you do? And you take them through. And if they want to make it painstaking, you don't worry. Your key is to extract as much information as you can about what they know about a particular situation. If you want to reference documents, be directional. I'm showing you what has been marked as plaintiff's number 2, which is a picture of the car and the condition that it was after the accident. Do you remember seeing that car? Or tell me what you know about the accident. Or tell me what that reflects in your mind. Now I'm using a document, a photograph, a picture, a writing, and having the person explain it. I might have them read from a document for some reason. I got the defendant, and I say, let me show you what's been marked as plaintiff's number 3. That is the actual contract that you testified previously you entered into. Can you tell me what you think it means in paragraph number 7, where it says, I must pay immediately? So you see that what I've done is asked a question about a document. So you can see that process. I personally never worry about what the opposing party's doing. If they want to object, if they want to scream, if they want to yell, I don't care what they do. I continue to look at the witness like it's between me and the witness. So if I say, please tell me what you did next. Objection, badgering, argumentative, harassing. You can answer, sir. See how I'm looking there? And generally speaking, the witness can answer. If I think that there's going to be a problem, I'll say either, are you instructing? I don't even look at him. Are you instructing the witness not to answer? Or I'll say, are you instructing the witness not to answer? No, you can answer. Okay? So what I'm doing is I'm keeping my eyes on the target, and then the target feels like they got to keep my eyes on me. So it's very important to keep good eye contact and to make it like you're the only 2 people in the room. This is a great way to go through the questioning process. In other sessions, we'll talk more about certain strategies that you can undertake, but the key is to have a point, to know what you're asking, to never be flustered, to be open-minded, to ask questions from answers, and to understand that you're there to get as much information as you can relating to that circumstance, whether it's be to prove or disprove a particular fact and issue, or to create something that you think will be useful later.